decision of the court. This Honorable Court has duly considered the submissions by the defense advocates, in particular the submissions by Mr. Kubasu on sentencing on behalf of the first accused in respect of count 1 and count 2, as well as the submissions by the other defense team led by Mr. Ndieki on the sentence to be imposed. The court agrees with the defense team that from the submissions from the prosecution, both accused are said to be first offenders and they have lived an upright life all their life, and that effort needs to be commended. On the application by the defense for the court to call further evidence under section 216 of the CPC, the court finds that indeed a pre-sentence report in form of the probation that is being sought could assist the court certain facts before sentencing the accused person. And the court and even this Honorable Court has time and again used this mode of report to enable it arrive at a just sentence. However, the law envisaged the pre-sentence report and the probation report to majorly help in the conjugation, especially for cases where the court is of the opinion that the sentence likely to be meted out is below the 3 years. On the first and second count, this court agrees that a pre-sentence report could help it arrive at a considerable finding. However, it finds that considering the accused persons are faced with other offenses under their SECA, that pre-sentence report may not help them much. So the Honorable Court is of the opinion and that in this particular case, it does not require a pre-sentence report, and that pre-sentence report will only but echo the plea in mitigation that has been brought forth by the defense team, which the court has taken into record. So it will therefore not be prudent to call for probation report and will delay this matter further. That input of the probation will not have an impact on the sentencing, especially on the counts 3 to 5. And equally, the court has also made an observation that pre-sentence report is a discretion of the court, and it is the court which will suo motu call for it when it needs that to be brought forth. On the submissions that the court treats the accused persons with lenience, the court equally agrees that being first offenders at their ages, they deserve some form of leniency, and considering the vast role they have played in the society as brought forth by the defense submission in their service in the civil service, and equally the society where they hail from. Being first offenders at their age, as the court said, is commendable, and the court observes that perhaps that could be the position because either the law has not caught up with them or they have lived a clean life. So sentencing policy and the law go hand in hand. The policy gives guidelines, but the basis of the sentence rests on the law. So where the law provides mandatory sentence, the court of law may not have a free hand, but where the court has been given discretion, the same should be exercised judiciously and in the interest of justice. So on the offences under the ASECA, the court may not have much discretion, as the fines are provided for, and the stipulation, particularly section 48 and 48.1 and 48.2, are premised on figures, and those figures can only be ascertained whether they are in each case, depending on depending on the circumstances. Mr. Gubasu urged this Honorable Court to find in the first and second count a figure that he gave of 100,000 in each count, and he cited a Court of Appeal decision. The figures that were posted, and also while being guided by the authority that was cited, the court will agree that the proposed fine is within the fine ranges of this court. The court has however taken into account the ages of both accused person and the circumstances under which the offense was committed. The court finds that the offenses are serious, and the accused persons took advantage out of a dire situation where the Kenyans were faced in the danger of hunger, and the maize was required to be important to save them from starvation. This court finds that a huge amount was lost in the process, and is therefore called to give a deterrent sentence. So the accused persons are sentenced as follows. In count 1, the law provides for a sentence for imprisonment for 3 years. But since the proposed amount appears reasonable to this court, the first accused is fined Kenya shillings 100,000 in default to serve 1 year imprisonment. In count 2, the law provides for imprisonment for a period of 7 years. However, taking into account the age of the accused person and being a first offender, she's equally fined Kenya shillings 100,000 in default 1 year imprisonment. Count 3 has 2 limbs. That is under section 48(1)(a) and section 48(2) on the quantifiable amount that was lost. So in respect of section 48(1)(a), where the proposed fine is not exceeding 1 million and a period not imprisonment for a period not exceeding 10 years, the accused persons are sentenced as follows. In count 3, the first accused is fined Kenya shillings 500,000 in default to serve 3 years imprisonment. The second accused is fined 500,000 in default to serve 3 years imprisonment. The third accused is fined Kenya shillings 500,000. The first and second accused are hereby ordered to pay, and in default, they will each serve a period of 3 years. So under section 48(2)(b), the NCPB lost a quantifiable amount, and each of the two accused persons under the law, which provides that the fine imposed to be equal 2 times the amount lost. In this case, the NCPB lost 297,086,505 times 2. So the first accused is fined here shillings 594,175, default to serve 7 years imprisonment. Second accused, similar amount, default 7 years imprisonment. The third accused, same amount. The first and second accused are directed to pay. In default, each of them will serve a further 7 years imprisonment. Count number 4, under section 48(1), first and second accused are each fined $500,000 in default, 3 years imprisonment. The third accused is fined similar amount, and the first and second accused are directed to pay. If they do not pay, they shall each serve 3 years imprisonment. Equally under count 4, the complainant lost a quantifiable amount, which is 13,364,671.40 times 2. So the first accused is fined Kenyan shillings 26,729,342.80 in default, 7 years imprisonment. Same amount for the second accused, default similar period, and the third accused is fined same amount, that is 26,729,348.80. The first and second accused to pay. In default of them paying that fine, they shall serve a further 7 years imprisonment. In count number 5, under section 48(1)(a), first accused, second accused are each fined Kenyan shillings $500,000 in default to serve 3 years imprisonment. The third accused is fined similar amount, and the first and second accused are directed to pay. If they do not pay, they shall serve a further 3 years. Equally in count number 5, NCPB lost a quantifiable amount under section 48(2)(a), which was USD 24,032 times 2. Therefore, the first and second accused are fined USD 48,064, similar amount, 48,000 in default, 7 years imprisonment. The third accused is fined similar amount. The first and second accused are ordered to pay. If they do not pay, they will serve a further period of 7 years. Under section 48(2), out of the offense, the first and second accused drew a benefit that is equally quantifiable, and the law provides twice the amount that they each benefited. So, in that respect, the first accused is fined in shillings 80 million in default to serve 7 years imprisonment, and the second accused is fined in shillings 100 million in default to serve 7 years imprisonment. They have a right of appeal within 14 days. And the second accused, being a public officer, the conviction to be served the Speaker of National Assembly and the Parliamentary Service Commission for purposes of compliance of Section 63(1), pending any outcome of any appeals. If the fine is paid, the court hereby makes further orders as follows. Out of the fine paid, out in count 3, NCPB shall be compensated amount equivalent to what was lost from its KCB account. In count number 4, similarly, if the fine is paid, the National Bank, NCPB will call it to be compensated to the extent of the amount lost from its NBK account as per count 4. Similarly, if the fine is paid immediately, an amount equivalent to the amount lost from Cooperative Bank be paid to NCPB. If the fine is not paid or the amount received is not sufficient for the compensation, the complainant shall be at liberty to take civil action for recovery 14 days, right of appeal explained. Yes.